On Law Weekly today, we discuss the Child Rights Act and especially issues of the girl child. We chat with a senior legal practitioner, Mrs. Fumi Falana. Also showing on the program today, the International Federation of Women Lawyers, FIDA, has condemned the failure of 10 states in the northern part of the country to domesticate and implement the Child Rights Act, plus a recap of some of the top trending legal stories. Hello and welcome to the program. I'm Shola Shoyeli. Just like always, Nigeria joined the rest of the world this year to mark the International Day of the Girl Child, celebrated every October 11. This year, issues of access to the digital space, security, and the provision of basic amenities to help the girl child fulfill her potential continue to resonate. My guest, Mrs. Fumi Falana, is all too familiar with these issues. Mrs. Falana is one of the country's leading women rights activists. She currently serves as the National Director of the Women Empowerment and Legal Aid, a non-governmental organization which defends the rights of women and children. She's very passionate about issues of the girl child, and in this interview, she talks about the plight of the girl child and the need to continue to use the courts to challenge norms, traditions, religious beliefs, and even laws which negatively affect this vulnerable group of people.
Not much has been done as to the rights of the girl child in Nigeria. And I want to begin from home. Now, in the family, the girl child is seen as inferior to her brother. Talking about access to education, in some parts of the country, even as of today, the girl child is expected to stay at home or to go learn a trade while the brother goes to school. And I'm sure you know this will eventually create a very wide gap between the education of women and men as they grow up. Then again, even a man and a woman in the house expect that when a woman gives birth to a girl, usually in this part of the world where we say, congratulations, you have a child. Say, oh, a boy or a girl? They will say, a girl. Say, oh, it's a boy. Oh, so that's, again, from the cradle, you already send the signal of unwanted, unrespected, inferior to the girl who is just coming to the world. And this she grows up with, and the girl is asked, go to the kitchen and cook, your brother go and play or go and watch television, go and play football. Why the girl? It is the duty of the girl to take care of the home, but it's not that of the man. So from there, she begins to develop this, the mentality of inferiority and sees herself as being inferior. Then again, when they begin to go to school, in school, the girl child is also seen as not as good as the boy. And so all these go on to affect the girl child psychologically and emotionally. Now, the essence of the International Day of the Girl Child is to create the awareness of the nations all over the world to the plight of the girl child. And of course, the plights include inequality in access to education, child marriage, child trafficking, domestic violence, which is very, very rampant, rape, indecent assault, child prostitution, hawking, and so many other things. Then again, we talk about violence in the society. The girl child is at the risk of rape. On the pages of newspaper, you hear stories of a child being raped, an underage being molested, even sometimes by stepfathers, men in the home, even people, quoted unquote, uncles. And so these are things that, again, we need to also look at. The law of rape in Nigeria, the law guiding the prosecution of rape in Nigeria, really, well, of course, we do have the laws, but the procedure is so cumbersome that it has become increasingly difficult to get people are prosecuted and of course convicted because of the so many technicalities involved. Of course, one of such that we have tried to campaign against and ask that should be expunged from the procedure is the fact that the rape girl, the victim, evidence must be corroborated. And you ask me, is it possible for somebody who wants to rape to call a third party to come and witness when it is not a dinner party that you invite people to come and witness? So most times we do not get people to corroborate the evidence of the victim. And again, from the time the girl is becomes a victim, you need to also keep some things in place like the underpants and other things. These, of course, are usually also defeated. And so we don't get this done.
What would you say is the way around that?
The way around that is to reduce the technicalities associated with the procedures in the prosecution of rape cases.
Is it by tinkering with the laws?
Yes, not just the procedure, the procedural laws, which also are developed over the years, can also be reformed. And this, we have been campaigning for this. Under the laws, we can reform this procedure. For example, it was part of the procedure of the law, where the common law procedure, that a married woman could not be raped. But the law has since gone beyond this. Because now, I'm sure you know, that we have marital rape. A husband can be jailed for raping the wife. Of course, if the wife does not give her consent and you go against the consent, well, you can be jailed for that. But in those days, it will be said that in marriage, your rights, all your rights have been submitted to your husband. But this, again, through judicial activism, which we are also doing now to reduce the technicalities in prosecuting the cases of rape, well, through judicial activism, those things also went off. And so now, today, we can validly say a man can be guilty of marital rape. So we are also looking forward to one day that we will be able to say, okay, this technicalities associated with prosecution of cases of rape have also been done away with. Again, we also want to appeal to many states. There is the Child Rights Act, which is the national law, but because the issues of children and women is under the exclusive jurisdiction. So it has to be by the states. The states must be the ones who make laws that govern these issues. And therefore, we are saying that for the Child Rights Act, they must be domesticated before they can validly be used in these states. And there are, out of the 36 states, as of today, we have only 22 that have domesticated the Child Rights Act.
Let's talk about the Child Rights Act. We've been on this issue of domesticating the act for a long time now. What do you think that we should be doing differently?
I think there are people in the states that can also go to court and compel them. This, again, is what we call judicial activism. I'm sure you remember there was a case, we went to court to challenge the regulation 124 of the Police Act. And the court went ahead to strike it down. And since then, it has become a law. You know, the beauty of legal profession is that the development of the law can be done through judicial activism. And this is what we call judicial precedent. When a matter is taken to court and a decision is obtained on a particular issue, if it is a decision of a superior court, it becomes the position of the law on that issue. Now, for example, the case we took to court on regulation 124, because it was a decision of a superior court, it has since, the position now has since become the position of the law as of today.
What does regulation 124?
Regulation 124 states that a female police officer who desires to get married must take the permission of her commander before she can get married within the first 3 years. But that, again, is not applicable to her male counterpart. So we took it to court based on the right to freedom from discrimination. Section 42, which states that nobody shall be discriminated against in the society, in the place of work, even at home, anywhere in Nigeria, based on sex. And the courts held that, yes, that is a fact. This law is, of course, very discriminatory against women, and so it should be expunged from the law. And so since then, it has ceased to become part of the law. And there are so many other laws that often patently discriminate against women. Now you will ask me, what happens to a man that impregnates a woman within the first 3 years? Nothing happens. So all these are things that also show that the rights of women, of course, vis-a-vis the rights of the girl child, need also to get more attention and to be more respected. Yes, and I was talking about child trafficking. Yes, this again is one of the plights of the girl child. You will notice that in homes, and I want to bring this to the attention of young mothers who are nursing mothers, who are working mothers, who take house girls, domestic servants. It is against the law to take any girl that is below 18. It is an act of slavery and torture to take any girl that is below 18 to be a house help in your home or a domestic servant, because that age between the age of 6 and 18 is a school age. They should be in school. And so if your own children are in school and you bring a girl to be a servant, that's slavery. It is against the law. And so they can be prosecuted for that. As a matter of fact, the Child Rights Act of Nigeria and the Child Rights Law of Lagos State specifically prohibits that whoever is found is guilty of an offense and can be liable to 3 years imprisonment. And it is the right of the child in Lagos State under the Child Rights Law to freedom of education, at least to JSS level. And so any child that is found on the street during school hours should be taken away from the street and registered in school. Especially the girl child. Now that we are celebrating the International Day of the Girl Child, we must also bring our attention to the plight of the girl child, especially their right to equal access to educational opportunities.
You've said a lot to us about the discrimination that the girl child faces, but what can be done about the religious and cultural norms that enable this?
It is the position of the law that any custom or religious belief that is inconsistent with the provision of the Constitution is null and void. And so all we need to do is to begin to bring to the attention of the people and campaign against these discriminatory practices that are discriminatory under the Constitution, as well as against the rights of the girl children. There should be more campaign and enlightenment. I want you to know that most of these parents do this out of sheer ignorance, because there is no religion that prohibits education. I was telling somebody this morning, no religion says that the girl is inferior to the boy. The boy child is sent to school, the girl child is asked to go and marry. There is nothing in any religion that says the girl child should not go to school. So we therefore should begin to enlighten them and campaign against these beliefs. And of course, like I said, one of the ways we can campaign against these beliefs is to take these practices to court. Go and test them in court. You have a right of a day in court. Go and test them in court. The beauty of our law is that our law, the development of the law can be gotten through judicial precedent. When you get to court, if a decision is made, it becomes the position of the law. There is a practice in the eastern part that was taken to court. Majeku and Ojeku. The practice was that a man that does not have a boy, a man that does not have a male child, if he desires a male child, can allow one of her female children to remain in her home, in his home, and begin to procreate for him. If she will now go out, get pregnant, it will be impregnated by another man, but bring the pregnancy home, and the baby will now be answering the name of the father. In other words, the baby will be that of the father, not of the biological father. And we went to court. The court said, no, it is repugnant to natural justice, and it is inconsistent with Section 42 of the Constitution, and so it is null and void. And so that practice cannot stand in the face of the law and should be expunged. So these are areas we should look at and see how we can reform our society through judicial activism, how we can reform our beliefs. Because I want to let you know that tradition and cultural practices are also dynamic. What you believe must move with time. And so as we progress, as we begin to also get educated and awareness of our people is going up, we also must begin to change our beliefs. And that is why we need a lot of campaign and a lot of activism to change the beliefs and the practices of parents, of the society, against the girl child in the society.
Welcome back. The International Federation of Women Lawyers, FIDA, has condemned the failure of 10 states in the northern part of the country to domesticate and implement the Child Rights Act. The group says the law will address the challenge of child abuse and violence against women in the face of the security challenges in the country. FIDA has also called on both the states and federal government to take more proactive measures to curb the rising attacks by bandits and terrorists in the north, a situation which it says has displaced so many children and women.
Gathered in this hall are female lawyers under the umbrella of International Federation of Female Lawyers, FIDA. Senior members of the bar and bench as well as traditional rulers are also here for the annual National Executive Council meeting of FIDA in Kaduna State. The meeting focuses on the rising insecurity in the country and the role of women in peace building. In her remark, the president of FIDA, Rhoda Tayodin, laments that the insecurity in the northern part of the country caused by bandits and terrorists has made children and women vulnerable to attacks and other kinds of violent abuses. While she calls on government to speedily deploy other proactive means of tackling the insecurity in the region, the FIDA president also calls on the 10 northern states that are yet to domesticate the Child Protection Act to urgently do so, adding that such piece of legislation will go a long way to protect children and women.
There are fantastic provisions in the Child's Right Law that children need to be protected. That law is a wonderful piece of legislation. It is all inclusive. Children are allowed to participate, they are allowed to say their minds and all that. So government and state government, especially in the north, the northern states, the 10 states are all in the north that have not adopted the Child's Right Law. And if some states in the north have adopted it, I don't see why other states should not adopt it. What affects a child in Kaduna affects a child in Zamfara, affects a child in Plateau and Borno and all. So why are we not ready to adopt the law? Our children go to wonderful schools and they are protected. You find security and all that. But you see children on the streets hawking, begging, cleaning glasses and all that. Something should be done about that.
The issues of penalties for rape offenders and violence against women and children also comes to the fore, as some of the female lawyers call for stiffer punishment against offenders to serve as a deterrent.
Too many cases of violence against women and children, too many cases of rape and defilement. We have many of them. At the last count, I had more than 400 awaiting trial of rape as at around early this year, awaiting trial in the prison. Yes, and thereafter we have several other cases that have come up. But women are becoming more informed, more educated, more enlightened. That's why we are beginning to have more reports of women who complain about violence in their marriage, who complain about their husbands beating them, battery, and so on. And also the issue of rape and defilement. This has been there. It has been there. Many young girls went through this before marriage. Most of the girls that lost their virginity was maybe due to rape or defilement when they were young children. In fact, at the last count, we agitated for life imprisonment and or castration for defilement, especially because that's the area I'm very worried about. The young children of less than 16 years. Well, our laws say young persons should be 18 and below. Now, our position is that for anybody who defiles a child that is under 16, the person should be sentenced to death. At worst, it should be life imprisonment and castration. Many international organizations are saying why so. They are not in support of death sentence. But I am saying that for a child that is like 3 months old, 6 months old, what is the attraction?
The menace of Almajiri phenomenon and child hawking still remain major social problems in the northern region, and the International Federation of Female Lawyers, FIDA, believes that the domestication and effective implementation of the Child Rights Act will protect children from such unhealthy practices.
And just before we go, let's bring you a recap of some of the legal stories that made the headlines.
We begin with the report that the Supreme Court has affirmed the former governor of the Central Bank of Nigeria, CBN, Professor Charles Soludo, as the candidate of the All Progressives Grand Alliance, APGA, for the November 6 governorship election in Anambra State. The Apex Court, in a unanimous decision by a 5-man panel of justices led by Justice Mary Odili, upheld the judgment of the Kano State Division of the Court of Appeal, which validated the primary election that produced Professor Soludo. The Supreme Court held that the appellate court was right when it quashed the Jigawa State High Court judgment that recognized a parallel primary election that was conducted by the Judo KK-led faction of APGA. It will be recalled that Professor Soludo emerged from the primary election that was organized by the Chief Victoria-led faction of the party. The rearrangement of former National Publicity Secretary of the People's Democratic Party, PDP, Olisa Metu, over alleged 400 million naira fraud was stalled at the last sitting of the court owing to the absence of the trial judge. Justice Obiora Guatu of the Federal High Court, Abuja, was said to be attending a judges' seminar in Lagos State. The court has now fixed February 15, 2022 for Mr. Metu's rearrangement. In Lagos, the Federal High Court, sitting on Wednesday, ordered a former Minister of Aviation, Mr. Femi Fani-Kayode, to pay a cost of 200,000 naira for being absent at his rearrangement. Justice Daniel Osaigo said that having gone through the court's file, he'd noted 5 different letters seeking adjournment on the same medical grounds. The court consequently ordered that the defendant, Femi Fani-Kayode, pays a cost of 200,000 naira or stand the risk of having his bail revoked. The Economic and Financial Crimes Commission charged Mr. Femi Fani-Kayode, alongside a former Minister of State for Finance, Nenadi Usman, one Danjuma Yusuf, a former chairman of Algon and a limited liability company, Joint Trust Dimensions Nigeria Limited. They were initially arraigned before Justice Mohammed Aikawa on a 17-count charge of 4.6 billion naira money laundering. They had each pleaded not guilty to the charge and were granted bail. The court has adjourned the case until November 30th for the rearrangement of the defendants. At the Lagos High Court, the 300-level mass communication student of the University of Lagos, Chidinma Ojukwu, and one Adedapo Quadri, both key suspects in the murder of the Chief Executive Officer of Super TV, Osifo Ataga, have been arraigned by the state government. The murder was said to have been committed in a service apartment in the Lekki area of Lagos State. The duo were arraigned by the Lagos State government alongside a third defendant, Chidinma's sister, Chioma Egbuchu, on a 9-count charge bordering on conspiracy, murder, forgery, stealing, and being in possession of stolen property. They all pleaded not guilty. After arraignment, Justice Yetunde Adesonya ordered the continued remand of Chidinma and Adedapo in custody, while the sister, Chioma, was allowed to continue on bail earlier granted to her at the magistrate court. The judges adjourned to the 9th of November for the Lagos government to call its first witness. And we round off with the report that the ex-leader of the movement for the emancipation of Niger Delta, Henry Oka, has lost yet another bid to get out of jail. He'd brought an application for bail before Judge Mabitsela of the Johannesburg High Court in September, saying he needed to be free in order to pursue his legal challenge of his conviction in the first place. The judge denied him bail. Mr. Oka was sentenced to 24 years in jail in 2013 for allegedly masterminding 2 bombing incidents in Warri and Abuja in 2010, where several people died and others injured.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shayeli. Thank you for watching and see you next week.